I know last year the M&A activity was crazy, right? I mean,
Right, right.
what's going on this year, first quarter?
I mean, it's to me, it's even more so. There's all
Really?
sorts of kind of new and exciting deals at kind of every different tranche that you could think of. I mean, I'm working on a deal right now involving the sale of like games to event venues. When you think of like private equity, you don't necessarily you think of like these big sophisticated companies, but they're coming in kind of on a distribution of a event venues type of fund, and they're even interested in that. So it's not. I mean, it's not just these kind of large businesses, or you think of like these large sophisticated people in suits. It's businesses of all types, and there's enough cash out there looking for a home that private equity funds are looking to deploy it in new and unique ways, probably in a way that we've never ever seen before in this space.
So even now, first quarter of 2022, the transaction volume is still there. There's still too much money out there, then they don't know what to do with.
Yeah, yeah.
Yeah.
That's just gotta. I think that's just going to be a trend going forward. I mean, I don't know if it's kind of a combination of the .com bubble at the end of beginning of 2000s, or you had the Enron scandals and a whole host of regulations coming in with Sarbanes-Oxley and other things that made uh, companies going public less attractive. But it seemed to, I think, at least catalyze a more mature uh, private equity space. And now it's not the ultimate goal of a company is now just not to go public like maybe it was 30, 40 years ago. Um, and you could be private and stay private and have access to capital in a lot of different ways than ever before. And
Yeah.
I think we're just seeing that come to fruition, especially now where there is a lot of capital out there. It's been trying to find a home for years, and even the pandemic really hasn't stopped that, because these private equity funds are looking for opportunities in good times and in bad times.
So, okay, so the space that I like to primarily work in is the lower middle market area. And are you seeing the same kind of trends in that space as well? Because a lot of these guys, yes, some of them will eventually sell out to private equity, but oftentimes it's other folks or individuals
Yeah.
or groups. Obviously, sometimes there's groups involved and PE involved. But what are you seeing on the lower middle market space?
Yeah, I mean, I it is part of it is private equity interested in that area. They're looking to kind of package up several businesses together and part of their strategic funds. And I think that's a driving force between some of the prices we're seeing. But it also is strategic buyers, and by what I mean strategic, usually the opposite. Private equity would think of, or a fund we would think of as a financial buyer,
Right.
even though they're operating as companies in that space. But when we say strategic buyer, it might be a competitor, or it might be a kind of a more traditional business looking into acquiring another company to either complement what they're doing or grow what they're doing and maybe taking a competitor off the market.
Yeah. Now, are you seeing any slowdown with the amount of deals coming in? I know the transaction volume in the with the P's, they're still looking for money, but are you seeing the slowdown because of what's happening with interest rates and access to funding? Are the deals slowing down from closing time? Like last year was insane, right? I mean, things would open, get it done, financing was available.
Mm-hmm.
Has there been any negative impact that you've seen, at least so far, with the interest rates going up, potentially going up, and lenders being maybe a little bit more careful than they were in previous years?
No, not really. I think not in the short term, at least. They're when we think of a lot of deals, we think of leveraged buyouts, but there's just a lot of cash available to
Yeah.
deploy. So you're seeing a lot of cash deals still happen. and I think the economics are generally still there for a lot of people in the M&A space.
What about the multiples? And so I'm assuming with all this cash available, then the multiples have not come down either, right? Those crazy multiples we saw are still being
Yeah, I
maintained.
would say so. I mean, it's interesting you say multiples because, uh, the way that the multiples seem to work is it creates the excitement, and you'll see a lot of big multiples because it helps the buyer kind of win the deal, and kind of, and there's strategies out there with different M&A companies or acquirers. Well, they'll come in with the big multiple, kind of clear the room, so to speak, and then start to try to claw
Yeah.
it back. And we spent a lot of time kind of playing defense
Yeah.
on things like that.
So let me ask you a question. Do you like being on the buy side of the transaction or on the sell side?
Oh, I guess that's an interesting question. I mean, in our practice and at my firm, we we're more on the sell than the buy. I mean, that's just been my experience over the last few years. That doesn't mean that we're not on the buy side quite often. It has more to do with our pricing and who our clients are. But
Wait, what does that mean when you say that? Is the sell side more expensive or less expensive?
no, I don't think ends up being kind of about the same. Um, Depending, a lot of it depends on who you're working with, who's on the other side, what their attitude is about approach to the deal. Are they arguing over every little point? Are they being productive in their asks and requests? So it really depends on the players involved. But the more sophisticated buyers, in my experience, tend to be the ones that ask for the most. That if they're coming in with a high multiple, they're generally asking for stronger reps and warranties. There's going to be an expectation that we warn our clients on the sell side about them coming back and making claims and asking to try to get some of that multiple back. The deal ends up being more sophisticated because the buyer will want representations and warranties insurance, which is an insurance product that kind of backstops the representations that the seller is making. So, and those are all things we kind of have to work through and figure out as the deal comes together.
Yeah, it's interesting you say that. That's sometimes we don't really understand from a business owner's perspective with that when we hand something over to the attorneys, we're always saying, why are they arguing over every single point, right?
Right.
And so it's interesting to get your perspective on it. So, I mentioned working in the lower middle market space. And one of the reasons I love this space is the people, right? So when you're dealing with the more corporate types, it's boring, right? You have executives, they're not the ones that built the business. There's no family history there. Mm-hmm. Whereas in this space, these are people that have, built this company, blood, sweat, and tears. Their hands, their stories, second generation, sometimes third generation, although that's being less and less now, right? And oftentimes these businesses, it's their puppy. Right. They're emotionally connected to it. And I know from my side, at least, watching them progress, develop their business, getting ready for a sale, just getting them to agree that at some point they're going to walk away from this one way or the other. Right. That's, there's this emotional toll it takes on them. And then we get to the point where they're finally there. They've made these plans. As hard as it is, they're ready to go. And we say, okay, now we're going to go into this. We're going to go into the hands of the attorneys, right? Up to this point, they've run the business. They've also been involved in negotiations, maybe, finding a buyer themselves oftentimes. And it goes into the hands of the attorney, and all of a sudden they lose complete control. And they've never been in this position before. And it's one of the most agonizing things for them. And, right. And you and I have seen this. So when it gets to that point, a lot of them, it's the first time they're seeing what an M&A transaction looks like. It's the first time they're seeing that the person that they did a handshake deal with, all of a sudden they have their representatives, their attorneys, and these guys are sharks, right? And now they're wanting everything. And all of a sudden this friendly deal turns into this hostile situation. So from your perspective, I know you get deals that come in sometimes early on, sometimes when, some negotiations have already been done. ideally, from an attorney's perspective, advising the transaction, like the sale of the transaction in this case, when is the ideal time that the attorney should be engaged?
So ideally, you're coming into our office kind of pretty early on, earlier than you would expect, at least to kind of have a conversation about um, the scope of our engagement and how we can provide value and help. And it's a partnership process. It's not just I think a lot of people have this idea that it's just like, oh, go get it done, you know. But it is a partnership in the sense from between the lawyer and their client to try to work together as a team to go get the deal done. So it could be, ideally the earlier on the better. We have a relationship and we've developed a trusting relationship and a way of communicating with each other to kind of launch this process. And then you're going into the LOI stage, and a lot of times we get brought in after the LOI stage because there's already a conversation going. People are talking terms, and so it gets jotted down on a piece of paper, and we get brought in and said, "Here's the deal." But in reality, it's better off if it'll go smoother if we're involved earlier on and trying to tease out some key deal points that weren't even discussed yet. But it's really up to the client and how they want to handle it. Throughout the whole process, there's a risk of the deal not happening.
Right.
And so you're going to be paying your attorney for something that you might not have a return on. The return might be that you didn't do a deal and that was the right decision, and I helped you get there, or our team helped you get there, but you don't have any realization of that. It's just, I'm happy I didn't go forward with that. That buyer was not going to be a good situation for me. So there is a tough decision that a client has to make is, okay, if I don't go to the law firm early and get them involved early on, I might be saving some money, but is it penny wise, pound foolish? And I'm sympathetic to that. I think we're all sympathetic to that you could spend a bunch of money trying to get the LOI in place and quickly realize that when you get to the finish line that it just didn't pan out.
Yeah. Well, it's interesting. You said there's a risk when you engage in the process because the deal might not happen for various reasons, right? One, because the other party doesn't want to do it, or maybe you don't want to do it after you start the process and you realize, hey, this is not a good idea. Mm-hmm. And so obviously those clients that we work with, they have advisors, we're kind of telling them what to anticipate, and what to expect, and helping them not kind of step on some of the minefields that, let's say, less sophisticated folks may step on. But in this understanding that there is this risk, right? A lot of times from a business owner's perspective, they don't understand the legal risks, right? And so, like you said, as they try to save a few bucks by trying to get it as far as they can and then getting the attorneys involved, oftentimes they expose themselves to problems that they never anticipated, such as the deal doesn't go through. And up until now, they've basically handed over customer information to a potential buyer, and the deal never happens. And there was no protections put in for them. And next thing you know, over the next year, they start losing half their customers. So how do you handle situations like that when a client comes in where they've made some mistakes? Let's say maybe they've opened up their books, their financials, but more importantly, their customer lists.
Yeah, their secret sauce.
Their secret sauce, right? At the end of the day, that's the holy grail there. How do you handle that? Does that put them, obviously, from my perspective, we're already going into this negotiation from a weaker spot. Obviously we want to avoid this, right? And that's why we're having this conversation with them. But how do you handle that if they've already done that? What should they expect? How should that be handled moving forward?
Yeah, I mean, there's a lot of kind of nuances to how we would handle that. A lot of times the buyer still wants the deal. I mean, more often than not, you're not dealing with kind of just a shyster who's just coming in, planning to steal information and planning to walk away. That is out there, and
Yeah.
you have to be careful about it. But the more that the deal progresses, each party is getting more invested in an outcome, and so they're spending legal fees, they're spending diligence fees, trying to get a deal done. The seller becomes more and more, we'll say, pregnant, or just the buyer is kind of getting more into what the seller is doing, and it gets harder and harder to unravel. So there is some momentum that we're coming in, we're trying to jump on and use. So if there has been some secret sauce revealed, I mean, we try to make sure there's an NDA. We kind of understand, okay, our negotiating position on this maybe isn't great, and we have to kind of pick our spots as to how we're going to help the client best to get the deal done, to make sure they get the purchase price proceeds in their pocket, and still trying to protect them the best they can. But that at certain situations, though, there are points where we just kind of have to do our best.
Yeah. But let's talk a little bit about NDAs. A lot of the business owners, they've heard of NDAs or they have an NDA. Some of them haven't, right?
Yeah.
And the first time you kind of bring it up, and obviously everybody wants to do it on the cheap. Maybe they'll go download a template from the internet, which is one of the biggest mistakes people make, right? Trying to do it on their own. So oftentimes when they're engaged with, let's call it a professional buyer, right? There are these entities out there that do a lot of acquisition, so they're very sophisticated. When it comes to the NDA, what should the selling entity, should they go with their own NDA, use the NDA of the buyer, get their attorney to draft one? Obviously, we want them to review the NDA before they sign anything, but typically, what's the standard practice when a buyer and a seller come together? Who's typically offering the NDA?
I mean, so in kind of the lower middle market space, the buyers kind of know that there's going to be some hand holding involved, and the sellers maybe don't necessarily have like their day-to-day attorney, or maybe they do, but it's more really helps on operations. They're not like an M&A attorney. So, a lot of times the buyer, being sophisticated, will kind of pull their form out and say, hey, let's sign this. And it depends on the buyer as to if it's going to be completely one-sided or if it's just kind of even-handed. But you have to watch out for the buyer. I mean, there's different deals going on formerly or currently where, the buyer's always trying to lock up the seller and kind of hold their hand to the deal. So it could be that the NDA has this long term. It could be that they sneak in some provisions that kind of create some exclusivity to the deal. Even if it's kind of gray area, sophisticators buyers know that gray area can lead to leverage. And so there's situations where a buyer we could have a mutual NDA. A buyer could disclose some information that it thinks is confidential, and then a deal falls apart. And then the seller could want to go find another buyer, and the buyer's like, no, we have confidential information disclosed, and we need to make sure you're not disclosing it to the other buyer. I mean, there's just kind of weird scenarios like that. Now, that's I would say it's more on the rare side, and an NDA usually kind of people kind of get it, blink, sign it, and move on with their lives. And you could argue whether, how enforceable it would be if somebody would actually file a lawsuit over an NDA, but it does happen. Right. But a lot of times I would say a lot of people just kind of get in and sign it, and hopefully you never have to see it again. But if people come to blows, it's open. It's open to be sued over.
Well, it's interesting. We're talking about something as simple as an NDA, which happens very early on in the process, right? And what you're saying is if you have these vultures, these sharks who are on the buy side, they could sneak things in there to give leverage all the way at that beginning.
Right.
And it really puts the seller in a very bad position. I've heard, numerous stories of sellers who try to do it on their own. They said, my deal's not big enough. I don't want to take a big piece of this pie and give it to the attorneys. And later on, they end up regretting selling the business, partly because what you said, right? As the deal started, they got excited, they got more invested in it. And it was by the time they discovered the negative aspects, they were too far into the deal. So my takeaway is from this is, look, if you're going to do this the right way, don't sign anything without having your attorney review what you're signing. You mentioned mutual NDAs, right? Can you talk a little bit about the difference between, one-side NDA versus a mutual NDA?
So when I say mutual, I mean both sides of both parties signing the agreement agree that they'll keep each other's information confidential. And in the M&A context, I think there's a good argument to say that a buyer shouldn't have any right to keep their information confidential because it's really the seller who's doing a lot of the disclosing. I mean, it depends on the context of the deal and how, like if it's a strategic buyer and maybe it's more of a merger of equals than just one kind of company buying out another. Maybe that makes sense. But from a seller perspective, we would come in and say, well, we're not going to give you any obligations. You only owe us an obligation to keep information confidential.
Right. So we talked about NDA as, one of the foundational documents that has to take place. And we talked about an LOI, which letter of intent.
Right.
Talk about a little bit about big picture process. What happened? What are the steps? Right. So, got a business owner, they're ready to sell. And let's say a buyer, they find a buyer themselves and they do the NDA, they start exchanging information. What information should and should not be exchanged at that point? And when does the LOI come in?
Well, I mean, I think early on you'll have some exchange of financials. I mean, people are interested in how much money the business is making, and you might kind of have a general overview of what you do. Usually the buyer already has an understanding, but you are working towards getting the buyer to kind of solicit a purchase price offer. And then from there, what are the terms of that? But at that point, the buyer is always looking to get more information. And you were talking earlier about disclosing secret sauce or customer information. And of course, the buyer wants to see it. The buyer wants to know what's under the hood, and what they're going to be buying right away. But like you said, you could be kind of giving away the farm, so to speak, or giving me the secret sauce of what makes you a lucrative business in the marketplace. And as a seller, you might be so excited to sell your business and get the deal done and all that stuff. You just hand it over. But you can hold that information a very long while in the process. I mean, we've gotten situations where we have LOIs in place, we have purchase agreements in place, we're already making disclosures, and we still haven't revealed our customer information. It's just here's a black line, and this is what they're bringing in.
Right.
And we can kind of generally describe who they are in the marketplace, but we're not going to give you everything about them until right before we're ready to close, and we have a deal done. So managing that disclosure information and really managing how the buyer is in the process. Sophisticated buyers, I think any buyer, but really even sophisticated buyers, they're always trying to get their foot in the door,
right,
and make it harder and harder for exit. Because that's the seller's biggest leverage. It's just to walk away. And so the more the buyer gets to know the employees and the HR and disrupt your whole business in this process, the harder and harder it is to leave the deal. And eventually they're wear the seller down. They're just like, this is so disruptive. We just need to get it done. Do what it takes to get it done. And you have to kind of resist that urge.
Yeah.
Not to mention that there's purchase price proceeds on the closing day coming your way, that could, that you're wanting to get. And if the motion is like, this money's right in my pocket, and my attorney or the other side's attorney or whoever is getting in the way of this, why? And it's all to make sure it gets done right and to protect you.
Okay. You said that, and caught my ear, when you were talking about at what point you give the secret sauce away or the customer list away, right? Mm-hmm. And right until the last minute. Where does due diligence come in? So can they do proper due diligence without looking at the customer list, or can you structure it in such a way that the deal's done subject to due diligence later? Can that happen? Or how do you walk the fine line there between what you allow them to see, due diligence, and finally here's the secret sauce?
Yeah. I mean, at some point as a seller, you have to take a leap of faith and you have to trust who you're dealing with. And there's really kind of no way around that. That fundamental issues, you have to trust who you're doing business with. And I think any business owner can understand that point. But, there's different mechanisms. One is, we get a purchase contract in place. Everybody signs it. We go into a period where we have different conditions to close, where basically one of the conditions is we're going to disclose this information. But otherwise, the parties have an obligation to go forward. I mean, this is kind of generally speaking. You can have breakup fees. You don't see that very often, but you could have breakup fees and say, look, we're not handing this over until, unless, if the walkaway price is X amount of dollars. So there are different mechanisms. Usually I'd say that's also rare, but so usually at some point it makes sense. You're far enough along. The parties now trust each other. It's just time to disclose that information.
Yeah. You said something about trusting the person you're selling the business to, right? Yes, business owners, they're very good at understanding who they're doing business with, and they understand that. But when it comes to selling a business, ultimately, assuming they're not trying to preserve their legacy, this is just, they've made a decision, hey, I just want the money, I'm out.
Right.
But they still want to do business with people they trust because of all the risks we're taking with the expenses, the legal fees, the advisor fees, the disclosing the secret sauce. What are some things that you've seen or you could share that maybe are telltale signs of someone acting in bad faith prior to engaging in this transaction? What are some red flags that folks could see and identify as a way to kind of, maybe take a second look at these potential buyers?
Is generally their approach to kind of saying, hey, we need to do it this way. This is our process. It has to be done this way. It's always done this way. I don't know why your attorney is saying it needs to be done this way. Situations like that where you start to get this kind of bullying approach from the buyer when you have counsel, like if you're hiring a firm like ours who has a strong reputation, who does deals all this time, is telling you, no, it doesn't have to be done this way. You start to see that, that when we're involved and we're working together, we're setting up boundaries to the buyer, and the buyer's not going to like that. And so there is this kind of back and forth process where you're negotiating and stuff. But at some point, you'll start to see that these guys, of all, don't have the money, and they're trying to scramble for it as they're putting your deal together. I mean, that's a tall tale sign. If they can't really get the money together, or they're delaying the process because it sounds like they don't have the money together, that's a really tall tale sign that you're kind of spinning your wheels. But yeah, I think there's a lot of situations where you can tell that the buyer isn't being forthright. And sometimes, it's a negotiation. They have their reasons. But when you get into, this is the way it's always done, this is tradition, and we're just arguing about what tradition is, I would say that's a tall tale sign that you're dealing with someone who isn't in the business of trying to develop a trusting relationship.
Yeah, I've had people come to me after they've had bad experiences, and then they finally say, okay, I need some advice here. But where they've had a potential buyer be so condescending to them, they would say things like, look, I've done 1,000 deals and this is how it works. And it's very insulting.
Right.
It's very insulting. You mentioned again, they might not have the money, the buyer. At what point is it customary to say, all right, I'm engaged in this process with you. I'm interested in you as a buyer and I'm willing to sell. Oh, by the way, can I see your bank account? Make sure that I'm not wasting my time. Where does that happen in the process?
I mean, it could happen pretty early on. Um, a lot of it depends on uh, who the buyer is. Um,
Yeah, like if it's a known
if it's
known
known
person.
quantity,
Yeah.
yeah, yeah, and you know that the funds aren't going to be an issue, um, then it's not something necessarily you're overly concerned about. But there are situations like maybe it's like somebody who's just kind of starting a fund. Then there's situations where it's like, okay, I've never really heard from you before. Like, I need to see some kind of history
Yeah.
of what you're doing and what you've been doing. And as a buyer, I think you can. There's certainly certain things that they can do to make you feel comfortable, um, that they have funds, or that they're working on getting financing. I mean, I think that's kind of a one of those leap of faith situations where it's like, I want to buy you, but I'm working on getting financing, and it's just, are they being forthright? Are they having a discussion about who
Right.
they're talking with? Can they answer kind of simple questions kind of plainly? Or is it like, well, we're still figuring it out. We don't want to.
Yeah. So if you draw the parallels to, let's say, the home buying process,
Yeah.
right? So, I know when I was buying my house, I see the listing and I take a look at the property, and then I have my agent write up an offer,
Right.
right? And so at that point, I haven't even done the inspection. I haven't done any
Right.
diligence other than maybe quickly taken a look. And so at that point, I'm disclosing how I'm paying for this, right?
Mm-hmm.
Right there and then, saying if this is going to be either a cash purchase or it's financing purchase. And oftentimes, if it's financing, I'm coming prepared with a letter. So the seller knows exactly what the
Right.
financial situation's like. Um, in in our world, right, when these folks engage in a back and forth, and then finally the LOI comes, maybe that's the first time they're disclosing how this is going to be financed,
Right.
right? And so there's nothing wrong with asking up front before you even sign that NDA. Say, look, do you have the money?
Right.
So you could have these informal conversations, right? And then I think one of the ways you could filter out if you're dealing with somebody who's serious or someone who's a good, honest person that you're dealing with is, ask them the questions up front.
Yeah.
And if later on during this process it comes out that, well, no, we actually don't have the money, there's your red flag, right?
Right.
Stop. Like, this isn't somebody we could do business with. We've been talking about the risk of, you go into this process, the deal might not work out. And I just recently had a case like that where we were ready to go. And then this condescending seller, they started kind of showing their true colors. And at that point, we're like, well, we're going to stop right here. And it was a very big disappointment to the seller because they were ready to go, right?
Yeah.
Emotionally, they were already spending the money on vacation somewhere.
Yeah.
What percentage of deals do you think fall through once they get to the stage of, where we got attorneys involved?
Oh, I mean, I would say, so we have attorneys involved. We have an LOI signed. The farther, I mean, it's tough to say. I mean, part of it is, I like to say that time kills all deals, which is eventually, as time goes by, it gets harder and harder. You lose momentum, the market could change, all these different things could kill a deal. But the more you interact with each other, the more kind of invested each party gets in the deal. So to say like a percentage, I think is pretty hard, because the things that kind of kill the deals, kind of also the things that kind of sneak up on you because you're doing the diligence. Everything looks great, and then you're doing the diligence, and you realize it's not working out. Or they're asking, you have an LOI. LOI looks great, then you get the purchase agreement, and they're asking for all these things. Or in the middle of negotiating the purchase agreement, they come back and try to retrade everything because they've gotten you so invested in the deal. And you're already you thought the deal was pretty much done. But in the background, they were working on other things and coming in and just decided to retrade.
Yeah,
deal.
which really speaks to, making sure that as a business owner, when you're getting ready to sell your business, you really build the best possible team around you of advisors and attorneys, obviously, as you can, because their experience in guiding you and what they've seen, and really is going to save you.
Well, and kind of one point along that question is a lot of deals tend to fall through, not necessarily because of legal diligence per se, but also because the seller just doesn't have his financials in order. Buyers, especially sophisticated buyers, like to see financials in a certain way.
Yeah.
And they might have kind of found a buyer and started this whole process. And then we open up the books and, they can't get a quality of earnings that matches up with what we were talking about in terms of financials. And so being prepared, not just from a legal standpoint, but also from a financial standpoint, with like working with you and people, Avo, to help put those together is going to make a deal go a lot smoother. So you're not in the middle of negotiating a purchase agreement and they're saying, well, this isn't looking the way we thought it was going to look.
Yeah, well, that's a whole conversation. Could take hours. But I've always said the hardest part of selling the business is getting the business owner to come to terms that yes, it's time. Yeah. Right. Everything else is supposed to be easier after that. Now, if they've gone through this process of reaching a conclusion that yes, it's time to go, typically the more methodical they've been, the more likely they are to be prepared to sell the business, right? Mm-hmm. And so one of the things that we do, obviously, is we assess, are you even ready to sell this business, right?
Right.
Obviously from a personal side, because, owning a small business, privately held business impacts their personal lives and their legacy and their families and everything that comes with it. But there's the emotional side as well, right? Do they know what they're doing tomorrow, the day that they're no longer in the business? Mm-hmm. How many times do you hear the story? Sells the business, never gets to enjoy it. Something happens. They're bored. And the whole, I don't want to get negative on that. But so is your business ready to be sold? And obviously, if we've done our job, if we've been engaged early enough, by the time the transaction comes, yes, we have audited financials. The company's in a position financially to be sold. We got the third party audits that further validate and give confidence to the buyer. So we make this transition fast. We may potentially increase the value because they already have some assurances, right? Mm-hmm. And so having the financials in place, having the understanding of what they're giving up, control wise. Sometimes these deals, there's clawbacks that they need to negotiate and they want to hold on to. But so I guess the big takeaway for me from our conversation today is, if you're a business owner and you're serious about maximizing the value of what you're going to get, and at the same time, if you want this process to be as smooth as possible, and you really enjoy this process, right? They've put so much into this business, their entire life's work. How many kids' birthday parties they've missed, graduations and things like that. And so they've put so much in and they want to get at least as much as they've put in out of the business. And here comes this glorious day. We're about to realize a lifetime worth of work that they've put in. And the last thing we want to do is have a bad experience. We want them to really enjoy the process, get the money, go celebrate, and the best thing that they could do is really don't wing it, right?
Yeah.
Understand that there's a process to this, there's a method to this, and go to the formalities properly, build a team, engage as early as possible, right? And eliminate as many of the uncertainties. Yes, there's going to be things that come up, even if you're the most prepared person in the world, because at the end of the day, you're dealing with an adverse party, right? No matter how friendly they are. And so start early on, build a team, and hopefully everything goes well, and you get to enjoy the fruits of your labor.
Yeah,
right?
Exactly. I mean, it is. We talk about trying to save on fees, professional fees, legal fees. I'll tell you, when we get a deal in, we'll get a purchase price and kind of have an idea of what it's going to cost. Right. But if the client comes in and it's organized, it has all its ducks in a row, I mean, our ability to charge fees goes way down, and you'll be like, we'll be sitting there thinking, well, I thought I was going to charge this, and it's way less because when we're making disclosures, it's already organized. Here it is.
Right.
We're putting it into the disclosure schedules, disclosure documents. We're handing it over, and we don't have to be the ones to pull teeth and help you scavenge for information. It doesn't have to be as disruptive to the business. And if it's less disruptive to the business, then that's leverage for you to go spend the time and resources to get the things you want, as opposed to backpedaling, trying to appease a buyer on some pretty standard diligence questions.
That's interesting you brought that up, right? Because what we forgot throughout this entire process is, while this is happening and the amount of time emotionally you're investing in this process and the deal may not come through, you still have a business to run.
Yeah.
And that business suffers, right? And so, going back to the pricing you talked about, obviously the lower middle market company, small business, they're very price conscious, right?
Yeah.
And the first question, obviously, whenever I say, okay, it's time to go talk to an attorney, how much, right?
Yeah.
Who's the guy and how much?
Yeah,
That's always the question. And obviously, price value, we could talk about that some other time. But what you said is dead on. The more prepared we are by the time we come to talk to the attorney, we've driven down the costs, right? If you're not going to pay, if you've done the homework yourself to gather this information, you may have paid somebody on your staff at their rate versus paying at an hourly lawyer's rate to put the same information together.
Right.
So being prepared is key. And the other thing is, if you've prepared, you got this package together. If this buyer doesn't work out, that's fine. Now we're ready. We're not doing the work all over again. We're not paying attorneys again. So preparation and being ready is really key. Jack, before we wrap this up, what's a piece of advice? I don't want to say advice. I know in the legal profession, you guys are very careful with that. But what is one thing that somebody contemplating selling their business, going into this process, what is the one takeaway you want them to have? What should they be thinking about?
I mean, I think that, I guess one thing is the deal's not closed until it's closed. As a seller, especially in lower middle market, I mean, once you feel like you get the LOI in place and you got the deal terms lined up, you might be thinking, okay, this is just paperwork. And then I'll just hand it off to the lawyer and they'll kind of write it up, and then we'll shake hands, and all of a sudden I have the money in my bank account. And in reality, it might be only the beginning, and it is a disruptive process. I know, like, a lot of entrepreneurs are good at scaling, and they like to get the dominoes set up, and we'll create these processes and make it efficient. And it's like, well, it's not necessarily an efficient process. It's about going and getting it done, and it's going to be bumpy. It's going to be disruptive. But if you have a good team and you're organized, you'll be in a position to be able to close on the deal that you wanted.
Oh, good. Very, very good. Very good information. Thanks, Jack. So